He is a Fox News legal analyst. He's a professor of law at George Washington University, and he's Jonathan Turley here on the Will Cain Show. Great to have you, Professor. I'd love to start here with the true-false with you. True or false? Among the cases against Donald Trump, this case brought by Alvin Bragg, the district attorney in Manhattan, in New York, is the weakest case against Trump.
True, but I want to emphasize that it's not weak in terms of chances of conviction because the jury pool, the judge could not be better for Bragg. But in terms of the law, the answer is true.
That led me, and you began to answer the second true-false. Although it is the weakest case, true or false, it is the most likely case to end in Democrats capable of yelling from the mountaintop, convicted felon Donald Trump.
Yes. I mean, the fact is that this jury pool couldn't be any better. You only had about 12% of people that voted for Trump in the last election. And so finding someone with an open mind about Trump is quite a challenge. If that proves to be the case, Bragg's not going to have to do much beyond introduce the defendant to secure a conviction. We're hoping that's not the case.
So we've established that it is both the weakest case and the most likely case to end in a conviction for Donald Trump. So let's dig in now, Professor, if we can, to not just what we expect to happen today, but let's at least set the stage together for how we got here. And I would love if you would indulge me to see if I can set out the facts and you tell me what I miss or if I get anything wrong. The charges here against Donald Trump stem from checks that he wrote to his former lawyer, Michael Cohen. The Trump team alleges these were retainers for the legal services of Michael Cohen. The prosecution alleges that the checks, which amounted to, I believe, roughly $150,000, were reimbursement to Cohen for payoffs to people like Stormy Daniels, another Playboy bunny, and I believe the publisher of the National Enquirer, to silence stories that would be negative about Donald Trump. So the allegation is Trump bought silence and funneled those checks that bought the silence through Cohen. And that led Bragg to bring charges of business fraud, of concealing your business and not properly filing as to what you were spending your money on. Is that a fair estimation of the charges against Donald Trump?
It is fair. And as you know, there are other rather wicked twists to this because what you just described is usually a misdemeanor under New York law for someone who's never been charged before. It'd probably be papered over or pleaded out. But in this case, the misdemeanor was dead. The statute of limitations had already run. So this is a real Frankenstein case. I mean, they're bringing to life a dead misdemeanor. And the way they're doing it is they're bootstrapping what they say is a federal crime. So they're saying, look, when he did all of that, it was really meant to hide the fact that he was committing violations of federal election law. And therefore, this is not just a live misdemeanor, it's a live felony, and we can bring this case. Now, to make this even more wicked, even the felony ran in terms of statute of limitations, but it was extended due to COVID. So it's sort of like a double dead indictment, but was revived. Now, the final wicked aspect to all of this is that there is no federal crime. This does not appear to be a violation of federal election law. The Department of Justice did not opt to prosecute it. So everything about this is absolutely absurd.
Okay, I want to dig into each and every one of those things that you just said, both the misdemeanor and the felony allegations, for just one moment before we pivot to the news of the day, and that is jury selection. So the official charge, the misdemeanor, Professor Turley, is, so that I start referencing it correctly, is what? What is the misdemeanor charge?
The misdemeanor technically is falsifying business records, right? It is making a false report essentially on business records under state law. Okay.
And for all the non-lawyers watching right now, let's explain what it means, I don't like taking anything for granted. Statute of limitations. I went to just enough law school to probably characterize this with you affirming it or telling me I got it wrong. But a statute of limitations in a criminal charge, Professor, is that you only have a certain amount of time as a prosecutor to bring a charge forward. And it's that the charge is somehow unjust if it is beyond that. The idea behind a statute of limitations is you shouldn't have to live 10 years past a potential crime for, I guess, new evidence to come forward. The statute of limitations in these misdemeanor charges had expired. So theoretically, and by the way, I think murder is one of the only crimes out there that doesn't have a statute of limitations. But the statute of limitations on these misdemeanors was what? I believe 4 years, and it had expired.
Right. And the irony here is that the reason you have statute of limitations is to avoid cases like this. I mean, the whole idea of statute of limitations is to tell citizens that they can go on with their lives, that there's not this Damocles sword that just dangles over your head. It's supposed to avoid cases like this, where a prosecutor can go back and dig up a former alleged crime and pull you back into court. And when he does so, time has passed. Recollections have dimmed. Witnesses can be more difficult to find. So it's not just that statute of limitations have passed, but this is the ultimate case of why we have statute of limitations.
All right. And then even if the statute of limitations had not passed, Professor, the misdemeanor charge of fraudulent business records, that would in and of itself be, in terms of prosecutorial discretion, what I mean by that is in terms of a prosecutor choosing to charge that type of crime, would still be somewhat unprecedented, right? Like we have various examples, which I think it would include Hillary Clinton, of similar type of incidences, falsifying business records, writing checks, passing them through a conduit, where prosecutors don't choose to prosecute these types of crimes.
Right. I mean, I've written about the analogy to the Clinton campaign, because in that case, you had Mark Elias, who's the general counsel of the Clinton campaign. Now, the campaign had denied to media that they had funded the Steele dossier when they were trying to get the whole Russian collusion thing going. It turns out that was a lie, and they buried it as a legal expense, very similar to what's being alleged here. They were fined for that as a campaign violation, but no one was criminally charged. So you're right, Will, in the sense that this is not a big ticket item. It's in terms of a misdemeanor, there would never even be a suggestion of jail time, but you also wouldn't have years of time and millions of dollars spent by all the parties to build up what is essentially a state misdemeanor case.
Okay, so what we've established so far together, Professor, is we have a weak state misdemeanor case that most prosecutors would not choose to charge unless the defendant's last name were Trump. Not only do we have a weak misdemeanor, we have a weak misdemeanor that has passed its statute of limitations. It has expired. Now, the tool, as you laid out for us a little bit earlier, that Bragg uses to get past the statute of limitations is he charges it up to a felony. Now, the way that he does that is he says that these checks, these fraudulent business records, were written not just to falsify business records, but to falsify business records to manipulate an election. So that they were used for election interference, in essence, to pull the wool over the eyes of the voter. Now, this, first of all, as a felony, I believe you just established for us, you just told us, the statute of limitations on that in and of itself, on that felony, that had also passed, Professor?
Right. The statute of limitations had been extended because of the pandemic. But the other problem, and this is what's so weird about the case, when the indictment came down, it didn't even state what the crime was. So the way they're bootstrapping this is they're saying, not only did you falsify business records, you did it with the intent of concealing crime. But when you read the indictment, it's not clear what that crime is. And when Bragg was pushed on this, when he filed, he actually sort of got miffed and said he doesn't really have to say anything more. To this day, it's ambiguous as to what that crime is, which is bizarre when you're about to try someone for a crime.
I think I'm leading you up to that point because I think that is, as you point out, beyond bizarre. Okay, so the statute of limitations for the felony is extended because of COVID. That's part of the Frankenstein project you just said to keep this alive. But as you point out, Bragg and the prosecutors haven't defined the underlying crime that makes this a felony. It's just this vague interference with an election. How does, if you don't have to, if you don't have to explain or even lay out in a legal filing, more importantly, lay out in a legal filing what your underlying felony is, I'm curious, how does this survive to the point of trial? This should have, the point, and we're going to get to this in our conversation, is this, as you said, it's so weak legally that A, you don't think it would survive appeal, but B, how does it even get to the stage of making its way to a jury?
Well, I think that is exactly why some of us are critical of the court. The court could have at least asked for greater specificity as to what the crime is. But there's a reason why Bragg wasn't specific, because it doesn't appear to be a crime. That is, it's not clear. And folks, many people believe you don't have to report money of this kind. The last time the Department of Justice tried anything like this was in the John Edwards case, another presidential candidate who did a very similar thing. There was money that moved from campaign donors to a woman that had had a child with him out of wedlock. The Department of Justice threw everything at John Edwards, and it collapsed. And the general view in the Department of Justice was, we really don't have the foundation to say that this is a clear federal offense. So that's why Bragg was ambiguous. That is, he doesn't want to come out and admit that not only did he revive a dead misdemeanor, a half-dead felony, but he's trying to bring to life for the first time a new federal crime.
Yeah, I had forgotten about John Edwards. It's almost on the nose, where he had a mistress. He hoped that wouldn't come out in the public. But in that case, the DOJ, despite trying, falls apart. And that's similar, or that's a lesson learned in this case, right? Because I believe the Southern District of New York, the Department of Justice at large, the Federal Elections Commission all looked at this potential case with Trump, and they passed, right? They said, no, it's either not there or we have precedent with John Edwards to say this will end up in failure, but that didn't stop Alvin Bragg.
Right. Unlike the Clinton campaign, there was no finding of a federal election violation, but the Department of Justice was highly motivated to charge Trump, and in fact did so, passed on this one, because they didn't believe they could get a conviction, or they didn't believe it was well-based. And they had experience with this. What they didn't have was a New York jury, a motivated judge, and a district attorney that doesn't really care.
All right, and now that's perfect. That's the perfect transition to the news of the day. Okay, we're going to dig into why Alvin Bragg doesn't care that his case is so weak, and let's talk about a New York jury. That's what begins today in this case against Donald Trump. In Texas, professor, we call it voir dire. Up in the Northeast, you guys are more fancy and you call it voir dire. But it is a French term for essentially selecting a jury. So today, I believe it's going to be roughly 100 people, something like that are brought into a courtroom. And the attorneys for both Trump and the prosecutors will go through the process of trying to find, I don't even want to use the word impartial, the right jury for their case. And so everyone has pointed out, as you have today, it is in Manhattan, a place where I believe the voting base went 85% for Joe Biden over Donald Trump. Now, why is that important? Because the point that Judge Merchant should be trying to help accomplish with these attorneys is to find an impartial jury towards Donald Trump. I just have to think, Professor, that's an impossibility. Like, we all walk around in the world. There is nobody, those that love him or those that hate him, I think there's nobody in America that's impartial towards Donald Trump.
Well, I think that's true, although we don't usually have a jurisdiction that is this one-sided. Remember, the New York voters elected James, the attorney general, on a pledge that she would back Trump on something. She didn't even say what. She just said, I'm going to get Donald Trump. And they elected her. Many of us considered that deeply unethical, but they elected her because that's what they want from the legal system. Those are that's the voting rolls that these same names appear on. And so the question is not whether people hate Donald Trump, but can they separate themselves from that hate? How intense is it? In this jurisdiction, it's pretty damn intense. Now, what you really want to try to do here is you only get 10 strikes. So you want to try to reserve your strikes for stuff that you can't show is clear absolute bias, because the bias is sort of freebies. If you could show a direct bias, then that limit doesn't apply. So that doesn't mean that they go on the veracity of these questionnaires, because the worst jurors, the ones you're afraid of, are the ones who desperately want to be on this jury, and they'll lie. I mean, we had that happen.
Right.
In past Trump cases, we had jurors that were found later, after verdicts, this involved Trump associates, had lied about their political activities. The judges refused to reverse the verdicts, even though some of us vociferously objected and said, what's the damn point? I mean, if voir dire means something to a defendant and they lie about their politics, clearly they should get a new trial. And these judges, 2 of them said, no, we're just not going to do it. So you have to nail it now. So what these defense lawyers have is they have the names, which we won't have. And those 100 people will be searched. So if they come out and say, look, I never attended a rally, I've never said anything against Trump, they will look on social media. Now, is that a complete protection? No, it's not. But what you're really hoping for is that, and there are good people, obviously, in New York, and good people who don't like Trump. And what you're looking for is not someone that doesn't dislike Trump, but somebody who likes the law more and is willing to give him a fair hearing.
All right, so it's my contention that you can't find 10 people in America that don't already have an opinion on Donald Trump that could truly describe themselves as impartial. But to my point, you add, look, you're talking about a district not only that went 85% Joe Biden, but that elected Letitia James as Attorney General of New York on the promise that she would get Trump, making it all the more absurd and impossible to achieve impartiality. These are the types of questions. Here's one type of question that will be asked of these jurors. Do you have any political, moral, intellectual, or religious beliefs or opinions which might prevent you from following the court's instructions on the law, which might slant your approach in this case? They go on, by the way, in some of these other questions to ask more specific things of the jury pool, like have you ever attended a QAnon movement, Proud Boys, Oath Keepers? Have you read books or podcasts by Michael Cohen? But in your estimation, so you pointed out, if you can establish impartiality, that's a freebie. You only get 10 strikes. So that means both sides say, without explanation, we strike that potential juror, and they're out. So in your estimation, were you sitting in there helping the defense of Donald Trump? What other things would you be asking of these jurors to try to understand who they are, that they either can't or won't explain honestly to you about their underlying beliefs? Like, how do you dig into that in voir dire?
Well, unfortunately, there's no way to take out the clever juror. I mean, if you've got a dishonest juror who just wants to hide their bias, they'll succeed. I mean, if it's very hard when someone says, are you so biased you can't say as a juror, to say, yeah, I'm that biased, right? I took this trip downtown, I waited this long, got on the stand to say, I'm the last person you want on the jury. A lot of people don't want to get dressed up for nothing, and they will be tempted to sort of brush over it. The only sobering aspect is that most people who feel strongly leave a evidentiary trail. Social media is the most common form of communications today. And even if you delete your social media, you can use Wayback and other ways to look at them. So it might be possible to find them, but is it likely that you're going to have some Trojan horse jurors? Yep. And they'll be carrying a lot of bias. But remember, you only need one juror to say, gosh, this is pretty weird. It doesn't feel like a crime to me to bring this to an end.
I was just going to ask that. For Donald Trump, all it takes is one. I have a good friend of mine. I've had him here on the Will Cain Show, Professor, who is a trial attorney, meaning he takes them late stage and he argues cases some 8 to 10 times a year, which you and I both know how rare that is for an attorney. Most of the time when someone says they're in litigation, that means they do briefs ahead of a court case. And he and I talk a lot about a jury and what a jury represents in the deliberation room. And he says how, and I don't know that it applies to this case because this is so unique. Most jurors do not want to take a strong stand. They don't want to lead. They don't want to have their opinion displayed before the other 11. So what ends up happening is the first strong personality wins. The first strong personality that lays down a claim will get the remaining, however, 9, 10 who haven't yet spoken to fall in line. I asked him, Professor, in all your years, have you ever seen a 12 Angry Men scenario? He said, never, because people are inherently agreeable. They want to be liked. They want to fit in. They want to be a part of the herd. So no one sits there and goes, you know what, guys, this just doesn't make sense. So if you're Donald Trump's attorney, I would think that adds up to you're going to need to find somebody with a very strong constitution or personality that can withhold their own opinion despite the pressure of 9 or 10 others. That's got to be the entire game for the Trump team.
Frankly, I think that's true. Now, you have jury selectors or advisors that look for those types of traits, but I agree with that. I'd be looking for someone that has a record of being a bit defiant, a record of independence, of going their own way, because that is the person who is not afraid to stand up. And, it's maddening I'm a criminal defense attorney, and it's maddening for those of us on the defense side, because often in close cases, you do get a hung jury, but then the judges give them an order. So they send them back and say, try again. And usually the language is pretty stern, saying, basically, you've come a long way, we've come a long way, you have a duty to try to resolve this. That almost always works in favor of conviction. And defense attorneys hate it, because usually what's happened is the jury's had a really difficult time, and there's a few people in there that maybe just 1 or 2 who are holding the line. And then the judge gives them this order, and a lot of these people end up breaking down and saying, all right, I don't want to hold up the show.
All right, so the last thing I want to ask you is back to, Alvin Bragg. So we've established how much he's had to Frankenstein up this case to even keep it alive. We've established how weak it is, which I think you and I could spend some time, but I think we both agree at some point, whether or not that's a New York appellate court or all the way to the United States Supreme Court, at some point its weakness is revealed in justice. It's overturned on appeal. But none of that really matters, right? Because Alvin Bragg is not here for justice. He is here, I believe, and this is my statement for you to agree or disagree with. The finish line for Alvin Bragg is to be able to say Donald Trump convicted felon. And even if that's overturned on appeal, that line will be established if he gets the right New York jury in time for a presidential election in 2024.
Well, I think that's clearly the case with a number of these prosecutors. That's why they're fighting to get a trial before the election, including the federal special counsel, Jack Smith. He's absolutely obsessed with getting a trial before the election. Well, why? Just because Trump is convicted wouldn't mean that he couldn't be elected president, but politically it has that impact. And Smith has also said that he is not inclined to follow the policy long held by the Justice Department not to bring cases or trials just before an election. So he's made very, very clear that he puts the timing of the trial as his priority in going against Trump. And you're right, after you get this jump scare of a verdict, it'll take it through the election. The problem is, I think starting with this case is a huge mistake. If they start with Mar-a-Lago, that's a case that has a lot of established law. It's not as much of a reach legally. It'd be harder to really say that was purely political. This one, it just stinks to high heavens. It's wrong on the law. It's very suspicious on the timing, and most people see it for what it is. So we'll have to see how much a conviction could possibly yield. And then finally, keep in mind, at the end of the arguments, the defense counsel can make a motion asking for a special instruction for the jury to be able to decide on lesser included offenses, in this case, misdemeanors. That is a real possibility.
Last question. Last question for you, Professor. So let's talk about mechanics for just one moment. If this results in a conviction for Donald Trump, that doesn't necessarily mean he goes straight to jail. He receives a jail sentence. It's a criminal case. But he could be out pending appeal, right, with bail. So he'd be running for president. He'd still be able to. I'm sure the court could put some limitations on his travel schedule. He would be able to run for president. He would be saddled with the moniker, with the label of convicted felon, and he would be out, though, to run for president without sitting in jail.
That's correct. I would hope the judge, given the weird nature of these crimes, would say, I'm not going to sentence you to jail, because that's a possibility. If he did, the assumption is it'd be a brief jail stint, but still, he has obviously Secret Service, other protection that has to be applied. It would create conflicts with the federal system. It would obviously yield to some pretty emergency appeals being taken. But in the end, being convicted of a felony doesn't mean you can't be a president. You can even incarcerate Trump and he could still be president. But it depends what the intestinal fortitude of this judge is. But I would hope that after this farcical trial, that this judge would not compound it with an actual jail sentence.
All right. Professor Jonathan Turley of George Washington, Fox News legal analyst. I think just a phenomenal conversation. I think laid the groundwork for understanding what's about to take place at most over the next 6 weeks in the case against Donald Trump. Thank you so much, Professor.
Thank you, Will.